2017 is the year which will be remembered as the year when the third pillar of democracy, the judiciary, that is the courts, very emphatically reminded the people and the government of India about the definition of the rule of law. In this year-end special, we take you through some of the landmark judgments which upheld the concept of justice, fairness and rights for all the citizens of India. A godman was sent to jail for raping 2 minors by the CBI Special Court, while his supporters tried holding the entire state hostage. The Narendra Modi government suffered a setback when the Supreme Court laid down the Magna Carta of rights of citizens in the privacy judgment and rejected the government argument that in a country of poor, privacy should be given a go-by. And right at the end of the year, the courts released the accused politicians in the 2G scam, saying there was no evidence to the contrary.
Verdict is out just now. Everybody has been acquitted.
1,76,000 crores. It is the number that caught the public's attention. Then Comptroller and Auditor General Vinod Rai's 1.76 crore loss estimate for the 2G scam and the then Telecom Minister's zero loss theory started the beginning of the end of the UPA regime. The 2G scam and the Congress's defense of it was the biggest ammunition for Narendra Modi and the BJP in the run-up to the 2014 elections. But at the fag end of 2017, the special CBI court acquitted all 17 accused in the 2G case, declaring that there was no evidence to prosecute the accused.
But full detailed judgment and reasons have yet to come. So I cannot comment on what the judgment says. But from whatever I know of this case, I had appeared for bail for some of these people in the Supreme Court some 5 years ago. The case turned on interpretation of Clause 8 of the bidding documents. And in my view, an interpretation of a particular clause of a bidding document can never lead to criminality. It is, at best, it could be a civil issue. And all these people of the industry who were accused in this case, they have suffered enough for the last 6 years. They have been unable to travel and their licenses have been cancelled. Therefore, I presume that the judgment would be saying that it's a matter of Clause 8, which cannot be a matter of criminality. And that's probably what has happened.
You can't push a Muslim woman to choose between her faith and her civil rights.
With none other than the Prime Minister making a pitch for the rights of Muslim women, the Supreme Court 5-judge bench declared triple talaq unconstitutional. It barred the customary practice which allowed the Muslim man to divorce his wife by merely pronouncing talaq 3 times. A heated political debate gripped the country, which put the practice of instant triple talaq or talaq-e-biddat at the epicenter. Muslim clergy called the move an interference in the religion, while Muslim women across the spectrum seemed united and welcomed the judgment. But despite a victory at the Supreme Court, women's rights activists and lawyers concede that bigger questions remain unanswered. With the move of the government to criminalize triple talaq, fresh complexities have come to light in the absence of codification of personal law.
It was very, very important for women from the Muslim community for their voices to be heard. We didn't want the government to be the sole representative of the voice of the Muslim women, and it was not. Today there is a move to criminalize triple talaq, and this is what makes us suspect the bona fides of the government in raising the issue of triple talaq in the first place. There is no other family law which makes divorce an offense, whether it's Hindu, Christian, or Parsi. So why should an attempted divorce in Muslim law alone be considered an offense? Now, why should these same grounds not be applicable for Muslim men as well? Today, there is a law which enables Muslim women to get a divorce on these grounds I just mentioned to you. But this is one of those very peculiar cases where a gendered law for women operates against them. That law, which lays down the grounds on which a Muslim woman can get a divorce, must be the same for Muslim men also to get a divorce. And last but not the least, why should a Muslim man be able to get an extrajudicial divorce, whereas a Muslim woman has to get a judicial, or a Hindu for that matter? A Hindu woman or a Christian woman, if she wants a divorce, she has to go to a court of law and prove any one of these issues, cruelty, desertion, etc. Why is it that the only exception to the rule is a Muslim man, not even a Muslim woman? Of course, you will be told that a Muslim woman can give a kula, but there she stands to lose her meher and any form of maintenance. So the ultimate solution, I think, is for the law to be codified and for the law to have a gender-neutral approach to the grounds for divorce.
The rape law, all laws relating to sexual violence in India are highly underused.
Just few days after the Triple Talaq verdict, tension started building in the state of Haryana as the CBI Special Court set the date to pronounce the verdict on Gurmeet Singh Ram Rahim, a self-proclaimed Godman. The court pronounced Gurmeet Singh guilty of rape on 2 counts. The women were living in the ashram or at Dera Sacha Sauda when he raped them. More than 40 people were killed in the violence and bloodshed that followed as the CBI Special Court convicted the self-proclaimed Godman on the sole testimony of 2 victims. This aspect of the law in this case has been less talked about, but experts claim that when this case goes up to the High Court for appeal, this will be the most contested aspect, as the courts have delivered conflicting judgments on the issue.
The sole testimony of the raped victim survivor has been part of our jurisprudence from much earlier. It did not dramatically come into being in 2013. And the Supreme Court in many judgments has held this. What is the nature of that testimony is very relevant. The court says it must be credible, it must be consistent, and it must inspire confidence. So it's not that any testimony of the woman is accepted. It is measured, it is evaluated, it is assessed. If it meets the standards set by the Supreme Court, then it is accepted. And the reason it's accepted is because very often, and almost always, except in scenarios of caste atrocities or communal riots, these crimes take place in private. Rapes are not going to take place in a public with many witnesses. Therefore, her testimony would probably be the only evidence. We do know that very often the body will have no marks of injury. WHO studies have established that. So who is going to say what happened but the woman? And what does the Supreme Court say? She's not an accomplice in this crime that you will disbelieve her. She has the status of an injured witness. But her testimony must meet the yardstick and the scrutiny that the court will apply. I think we pay less than lip service to it. If some woman says that I fear that if I depose, and surely Ram Rahim is a very powerful man, that that's an understatement for anybody. I mean, I cannot think of more courageous women than those young women and their families who've taken this risk. For them to go forward and depose, what is the support the state provides? To say, oh, we will give victim protection or witness protection. What comes in the garb of victim witness protection? They'll give you 2 constables with guns who will stand outside your house. Is that how threats work? Is that how intimidation works? The way it works is that there are people it's a whole network of intimidation and threat and coercion, which will operate at different levels. There is nothing in law to stop that operation. By the time they're going to move the court processes, everybody would have persuaded and convinced them that it's not worth your while, you're better off suffering this indignity and this violation rather than taking this risk. So and what really to my mind is the best witness victim protection? It's a fast, speedy trial.
So why should Rajesh and Nupur be constantly hounded as to what you are doing for providing justice to your daughter now that all right you have got acquitted or not? That is not the question. The question is that what is in their hands to provide justice? They are actually, according to me, they are victims themselves.
And after spending about 4 years in Dasna prison, the Talwars were freed by the Allahabad High Court. The High Court came down heavily on the judgment of the trial court and questioned the entire theory of the investigating agency. The High Court also said that the trial court and CBI produced an imaginative theory which is completely contradictory to the principles of criminal law. The Talwars were let off after a witch hunt by the media, which continued at the trial court. But even today, question remains unanswered as to who killed Arushi, and has justice been done?
The way the Talwar story was projected, especially by some police officers like that Gurdarshan Singh of Noida Police, and the way they projected the parents, the 13-year-old, without any evidence, in about 2 days' time of an investigation, without having any credible evidence in their hands, they slew the character of a 13-year-old. They slew the character of the parents and introduced elements of sleaze, sex, crime, passion, police, drama into the story, which turned the case into something which I called as tabloid gold. Though, ideally, in an ideal situation, a media frenzy of a constant reporting, of a constant dominant narrative, made, circulated, rehearsed, and printed and videographed and again going in a circle, ought not to affect the due process of law, especially the judgment of a judge and his judicial scrutiny of evidence. But at the end of the day, everybody is a human being. And who says that judges don't have monkeys on their shoulders? They also have, some conceptions about a lot of things. So as far as the media implosion into the trial is concerned, this kind of unfathomed, unparalleled media intrigue into the trial, I think it does definitely affect the quality of justice at the end of the day, though ideally it should not. When you go and you write a judgment, you don't go to Middle-Age French, Middle-Age Latin, and Middle-Age English. It shows that the writer of the judgment is himself suffering from some kind of inferiority complex, and if wants to send an appeal to a particular class and section of the society. And unfortunately, what happened in the trial court judgment is that when it came to appreciation of evidence, unfortunately, common sense took an adjournment.
Judgment of Justice Lokur, in which he says that you can't have sex with a minor wife. But should we not have asked the question, how did this minor become a wife in the first place?
In a landmark judgment, the Supreme Court has criminalized intercourse with a minor wife. The exception under Section 375 of the Indian Penal Code gave immunity to the husband if the wife is above 15 and below 18 years of age. Doing away with the exception, the court has done a purposive interpretation of the law, rather striking it down. The top court said that the distinction that the law makes pertaining to age of consent between a married and an unmarried girl is artificial. The judgment also brings in harmony conflicting laws on the age in consent. While the IPC said one can have sex with wife of the age of 15, POSCO prescribed the age of consent to be 18. But like in the case of triple talaq, many questions continue to remain unanswered. The key anomaly is that the law against child marriages deals with prevention and punishment against those who facilitate child marriages, but marriages between minors are not void ab initio unless, upon becoming a major, one of the parties seek for the annulment of marriage within a prescribed period. So legally one can marry even when both or one of the parties is below 18 years of age.
Entrenched vested interests in states like Rajasthan are so strong that it's almost as if they believe in child marriage with a religious fervor. Okay? And until that changes, child marriage will continue. But to come back to the law, you wanted to know about the law. Yes, the law has certain progressive elements. So, for example, and I know it's been used, but I know NGOs in Rajasthan have actually lodged complaints when they have come to know of child marriage which is likely to take place. But the girl herself will not be in a position to lodge that complaint. She will be too intimidated by all the... See, she's in a custodial situation, whether it's with her family, natal family, or whether she's with the husband's family. So she herself will not be able to lodge the complaint. But the law does have this ability to. It also gives her the right to have the child marriage declared void.
So that's what I was coming to. So it's not per se void, right?
No. She has to move the court after attaining majority.
Why are child marriages not per se void?
There is no good reason except that, as the government of India says, this is a social reality. And if we make them void, we'll be left with a whole lot of women who are married but not married. And of course, what they mean is by that time they might have had sex with this guy. And then, if you declare the marriage unlawful, then who's going to marry them? In future and all. It's all mixed up with issues of stigma, religion, backward-looking ways of handling a situation, and a complete absence of state policy to end child marriage. It's not going to end on its own. A conscious intervention is required to end child marriage. So no, they're not being declared. They're not ipso facto void. Which is a shame. It's a shame. It's a blot on the face of this country. So if your question is, could they have done more? I think they could have done more in the field of child rights. They could have done more in the field of child marriage. Okay? It wasn't a case about rape. It was a case about child marriage. Okay? And it need not have been a case about sex. It could have been a case about the validity of a marriage. And as I said, if it was seen as a case about the validity of a marriage, it would have actually set a lot of women free. So in that sense, they could have done much more.
Well, it was surprising that the Attorney General, the previous one and the present one, actually contended that there is no fundamental right to privacy in our constitution.
And at last, the most important judgment, not just of 2017, but possibly of the decade. It is the new Magna Carta of rights of citizens in the modern democratic state. A 9-judge constitution bench upheld privacy as a fundamental right emanating from the right to life under the Indian Constitution. In an unanimous verdict, the Supreme Court rejected all arguments of the centre that privacy has a limited scope in countries like India. The top court's ruling will have impact beyond Aadhaar. Issues pertaining to homosexuality, reproduction rights of women, privacy policy of leading service providers like WhatsApp and Facebook will now come under the scanner. The centre questioned the status of privacy and its existence. It argued that citizens don't have absolute rights over their own bodies. It even told the 9-judge bench of the Supreme Court that in countries like India, with mass poverty, privacy can be given a go-by. But now the writing is on the wall. Citizens of the Republic of India have an overarching right against the state and also the new quasi-government multinational organizations. The case of homosexuality breathes a fresh life with the Supreme Court judgment directly criticizing its earlier order, which restored Section 377 and left it to the legislature to decriminalize homosexuality. The court even commented that what people wear, eat, or how they dress is nobody's business.
Well, I think that throughout the privacy judgment, the underlying broad point is that there has to be a rule of law. And that is also in the Aadhaar case also. So coming to your first point about, the choice that a person makes, what clothes to wear, what to eat, who to have sex with, what entertainment to have, what festivals to observe. These are matters, and what religion to follow. These are matters of personal choice. And nobody, not only the state, but no other person can impose that kind of choice on any individual. So I think it's a fundamental issue that we are dealing with in the privacy judgment, which will flow into the Aadhaar case, because there, the issue is whether I need to have my data and my information to be disclosed to the world at large. The way it stands today, there are no statutory laws to back what they are doing, and that is the issue of rule of law. So that will be one very fundamental point which relates both to rule of law and privacy. The privacy judgment indicates that there should be data protection, but what principle have to be followed is not clearly delineated. There is the European data protection now which has come in, which gives you a lead. The very shocking and surprising thing about the Aadhaar thing is that this should have been thought about much before they implemented the schemes. The Aadhaar scheme and the act and the project is full of changing everything as it goes along the way. There has not been sufficient thought given right at the beginning. There was no law and they were preaching privacy. There is a law, there is no data protection. Data protection will come afterwards. It shows the way the government has been functioning on this issue, where your information is being made available to the corporates for them to use without concern about a person's privacy rights. It's a very shocking state of affairs in my opinion. And I think that is one of the major reasons that the Aadhaar scheme has to be opposed. In fact, if you look at the act, it is the corporates who are going to benefit out of this act, because they will get data, and that Section 8 facilitates them to share data with corporates so they can make money out of it. So the people who are actually the ones who are targets of PC Act, Prevention of Corruption Act, are actually getting away with it, and the ordinary people are being told, we don't trust you because we think you are dishonest. This is a very shocking state of affairs, in my opinion. So I think the sooner the government realizes they are on the wrong track, and not only this government, this is brought about by the earlier government also. All governments have this notion that corporates and government are very clean, but ordinary people are actually corrupt. But the reality we know is otherwise.